Namaskar. A very good afternoon to respected district and session judges across Punjab, Haryana and UT Chandigarh. I also heartily welcome all the other judicial officers who have assembled here for today's webinar. So, on 11th of January 2022, Honorable Supreme Court of India, in the case of Smriti Tukaram Barare versus State of Maharashtra, had desired to regularly conduct the programs on the guidelines for recording of evidence of vulnerable witnesses in criminal matters. So in view of the said directions, we, Chandigarh Judicial Academy, is organizing this webinar with the topic recording of evidence of vulnerable witnesses and protection of witnesses in criminal matters. This webinar will be taken up by Madam Sonia Kinra, who is the faculty member as well as additional district and sessions judge with Punjab cadre. Ma'am joined the judicial services in the year 2004, and after holding several assignments, she was promoted as additional district and sessions judge in the year 2016. Ma'am joined the Chandigarh Judicial Academy last year in the year 2021. I welcome you, ma'am, on this webinar. Before I go further, I would like to make an announcement that due to paucity of time, we would not be able to take up the question and answer session. However, after the conclusion of the webinar, we are expecting the feedback forms from the audience, and you can ask your questions. You can put your questions in that feedback form, and hopefully we shall be able to address those questions in subsequent webinar. So without further ado, ma'am, I again welcome you, and I have also gone through this scheme, but I still have some lingering questions in my mind, and I hope that you will be able to clear them. For example, ma'am, we are curious to know as to who are vulnerable witnesses, how their interests can be protected, what is the mode of recording their depositions, how their privacy is maintained, and how protection can be given to the witness facing threat in criminal trial. So, ma'am, I hope you will be able to answer all these lingering questions in my mind. So over to you, ma'am.
Thank you, Harshali ma'am, for your kind words, and I hope I'll try to reply to your queries. Namaskar and good afternoon to all respected district and session judges of the states of Punjab, Haryana and UT Chandigarh, and my esteemed colleagues. I know imbibing of things at this hour of the working day is little bit difficult, but with the aim to simplify the things, I have prepared PPT with one video. And I hope you all would enjoy the presentation in the next hour. As stated by Harshali ma'am, with regard to the direction issued by the Honorable Apex Court, the other direction is to ensure that at least one permanent VWDC, Vulnerable Witness Deposition Center, be set up in district court establishment, and to formulate the guidelines by all the high courts on the basis of the guidelines of Delhi High Court for recording the evidence of vulnerable witness. We all cannot deny the value of witnesses, keeping in view the dependency of the criminal proceedings on the testimonies and cooperation of all the witnesses at all stages of the proceedings, and the critical and fundamental duty of the witness to make path to push offenders into the realm of justice. We need to talk about the method of recording of evidence of vulnerable witnesses in criminal matters, and the definition of the same on one hand and protection of witnesses on the other hand. So this session will be of two parts. One with regard to the guidelines on the recording of evidence of vulnerable witnesses in criminal matters, and second part with regard to Witness Protection Scheme 2018. So before coming directly to the guidelines, I would like to draw attention to the brief history to have better understanding of the guidelines framed. Section 327 in the CRPC is there, but by the Act 43 of 1983, there were amendments in Section 375, 376 of IPC, and Section 114A was inserted in the Indian Evidence Act. So consequently, subsections 2 and 3 were added in Section 327 of CRPC. Otherwise, 327 CRPC states that the trial criminal court will be holding the trial in open court. And that court has to be open. But these subsections were added owing to the nature of the offense of rape. And they were with regard to the offenses of rape that they should be conducted in camera. And other thing which was added, it was regarding the fact that the printing or publishing of such trial is not permitted, except with the previous permission of the court. Thereafter, in the case of Gurmeet Singh in the year 1996, it was held that the courts are obliged to act in furtherance of the intention expressed by the legislature under section 327(2) and 3 of CRPC, and to hold the trial of rape cases in camera. But it was also desired by the Honorable Apex Court that the cases of sexual assault on the females are tried by lady judges wherever available. Further, it was desired to avoid disclosing the name of the prosecutrix in the orders. So continuing with these directions, in the case of Sakshi, which is very well-renowned judgment, the subsection 2 of section 327 CRPC that to conduct the trial in camera was directed to be applied on the offences under sections 354 and 377 IPC as well. Further, with regard to the procedure aspect, it was held that the trial of child sexual abuse or rape shall be conducted by having a screen or some arrangements where the victim or witness does not see the body or face of the accused for truthful eliciting of the deposition of the witness. Second direction was that the questions which are directly relating to the incident be putting in the cross examination should be given in writing to the presiding officer, and they should be put to the witness by the presiding officer in a language which is clear, understandable by the witness, and is not embarrassing for the witness. Third direction was that during recording of the testimony of such witness, small breaks must be there as and when they are required and felt by the court. Then continuing with these directions, in the case of Mahinder versus State of NCT, the Delhi High Court issued the directions with regard to the offences involving the child victim to the police, magistrate, doctors, and even the court who is to record evidence of the child witness, apart from some other general guidelines. And on the basis of this judgment, the Honorable Delhi High Court framed the guidelines for recording of the deposition of vulnerable witness. So the guidelines came into existence for the first time after this pronouncement. Then came the case of State of Maharashtra versus Bandhu. In this case, the Honorable Apex Court issued the direction for establishment of special centers for examination of vulnerable witnesses in criminal cases. This was with the object to have conducive environment for recording statements of such vulnerable witnesses. And it was again dwelt on the guidelines which were issued by the Delhi High Court for recording the evidence of the vulnerable witnesses in criminal matters. And it was also noted, that is in the year 2018, that these special centers have already been set up in Delhi for that purpose. Thereafter, the very popular case of Bapu Asaram, that is Mahinder Chawla versus Union of India, came, in which again the directions laid down in the case of Bandhu for setting up of special centers for examination of vulnerable witnesses was stressed upon, and the Apex Court adopted Witness Protection Scheme 2018 in its entirety. Then comes the case due to which we all are here, the case of Samriti Barade versus State of Maharashtra. It's Samriti Tukaram Barade versus State of Maharashtra. In this case, apart from directing to set up the VWDC, the definition of vulnerable witness has been widened up. Though it was defined earlier in the guidelines framed by the Honorable Delhi High Court, which were only including that the vulnerable witness is the child who has not attained the age of 18 years. But now this definition has been expanded. And this is the main issue, that who is the vulnerable witness? Before replying to the query of who is vulnerable witness, I would pose a question: who is a witness? In my view, the witness is having the first-hand knowledge about a crime or incident which is perceived by him or her through any of the senses, including touching, seeing, hearing, or smelling. And the vulnerable witness, now, which comes after the pronouncement of the Apex Court, not only includes the child below the age of 18 years, but also any victim of any age who is the victim under section 354 IPC, that is of the sexual assault, or we can say about the modesty of the woman. Then comes the any victim, maybe of any gender, who falls under the definition of 2D of the POCSO Act. Third vulnerable witness is the any victim, maybe of any age or of any gender, who is victim of the offense under section 377 IPC. Then comes the witness who is suffering from mental illness, which is defined under section 2S of the Mental Health Act. Now, under Mental Health Care Act of 2017, section 2S flows that mental illness means a substantial disorder, which could be of thinking, perception, memory, which grossly impairs the judgment, behavior, or capacity to recognize the reality or ability to meet the ordinary demands of life. All the mental conditions which are associated with the drug abuse or abuse of the alcohol, but it does not include the mental retardation. So mental retardation does not fall under the definition of 2S or the mental illness. Next vulnerable witness is the witness who has the perception of threat and is provided the protection under the witness protection scheme of Union government, which has been, as stated above, approved in the case of Mahinder Chawla. Thereafter, next category is the any person who is having disability, which could be of speech or hearing or any other disability, and who is considered to be vulnerable by the competent court. Last category, which includes that any other witness which is deemed to be vulnerable by the court concerned. So these are the categories which have been added to the categories of vulnerable witnesses apart from the child below the age of 18 years. Now, what are the objectives of the guidelines? There are three objectives. Firstly, to elicit and secure complete evidence from the vulnerable witness. To minimize harm or secondary victimization, which could be as a result of participation in the criminal justice system at the hands of the various stakeholders. And thirdly, by ensuring that the right of the accused to a fair trial is maintained. So all these things are kept in mind while framing the guidelines. Now there are some of the important terms. We have already discussed the term vulnerable witness. Now the terms come support person. Support person, it includes guardian ad litem, legal aid lawyer, facilitator, interpreter, translator, and any other person appointed by court or any other person appointed by the court to provide support, to accompany, to assist the vulnerable witness, to testify, or even to attend the judicial proceedings. There is another term, concealment of identity of witness. It means and includes any condition which prohibits the publication of any particulars of the witness which may lead to identity of that witness, which may include the name, address, even the parentage, school, village, or the town, or the locality where he or she is residing. Next comes the term comfort items. It is used in view of the child witness, that the witness, the child, with which article is comfortable at the time of deposition, as some of the children are very comfortable with some of the toys, some blanket, or anything, any article of their choice. So they can be allowed to carry these comfort items with them at the time of deposition. Then comes the term competence of a vulnerable witness. As defined under section 118 of the Evidence Act, that every witness is competent to testify. Similar is the definition here, that every vulnerable witness shall be competent to testify unless the court considers that they are prevented from understanding the questions put to them, or from giving rational answers to those questions, which could be due to their tender age, disease, either of body or mind, or any other cause of the same kind. Further, it has been explained that a mentally ill person may also be held to be competent unless he is prevented by his lunacy to understand questions. So it has to be seen at that time whether he is able to understand the questions and answer them rationally. Then comes the term courthouse tour. These guidelines have introduced one new feature. It is the pre-trial tour of courtroom. This is with the purpose to familiarize a vulnerable witness with the court environment and with the procedure, basic procedure which is going on in the court, and with the roles of all the court officials who are sitting on the dais or otherwise, so that whenever the witness comes, he can depose in a comfortable manner. Next comes the live link. As we are conducting this webinar, I think it is very much clear from the term. This is the live link, including a live television or audio video electronic means or other arrangement where a witness who is absent from the courtroom but by remote communication is able to be examined and cross-examined in the courtroom. Now the two terms come secondary victimization and re-victimization. As I have used the term secondary victimization above also, so it means that the secondary victimization, that the victim who is already undergone the trauma of any act, any criminal act at the hands of the accused, he is questioned as an accused, has to undergo the victimization for the second time. This is the secondary victimization that is at the hands of the stakeholders. And re-victimization means a person who is suffering from the trauma, he is being suffered again and again. The criminal act is being caused again and again over a period of time to him. So it is at the hands of the accused. Now even the term waiting room has been defined. It has been stated that this waiting room should be a safe place where such witnesses can wait, and such waiting room shall contain toys, books, TV. Again, it is for the conducive environment for the child witness or the vulnerable witness who has come in the court. There are some other terms which have been introduced in the guidelines, and I have just picked up from the guidelines and prepared these PPT for ready reference. This is the guardian ad litem. The court may appoint any person, which could be a member of bar or that is the practicing advocate, but not a person who is witness in the proceeding involving the child, as guardian ad litem. Now this guardian ad litem could be to a victim or even to a witness to a crime. And such orders, before passing of such orders, what has to be considered? It is the background of the person to be appointed as guardian ad litem, his familiarity with the judicial process, social service program, and child development. And even for appointment of the guardian ad litem, the preference should be given to parents of the child if they are qualified. Now coming to the duties of the guardian ad litem. The duties which have been defined are to attend all depositions, hearings, and trial proceedings in which a vulnerable witness participates. Such guardian ad litem can make recommendation to the court wherever the welfare of the witness is required by keeping in view the needs of the child and observing what impact is there of the proceedings on the child. Guardian ad litem shall explain the vulnerable witness in language which is simple and understandable with regard to all legal proceedings, which includes police investigations in which the child is involved. He shall assist the vulnerable witness and family in coping with emotional effects, and shall remain with the witness while the witness waits to testify. So these are the duties which have been assigned under the guidelines. Now next term comes the support person, as we have referred in the definitions also. Support person ordinarily is a neutral person. Guardian ad litem should be preferred to be a parent, but he is a neutral person other than a parent. And only in exceptional circumstances, the parent should be appointed as support person. If no other suitable person is available, only then in rare cases, another witness of the case can be appointed as the support person. But if it is done so, the testimony of that support person has to be recorded prior to the ipse dixit of the child. And such support person shall be allowed. I'm using the word shall be allowed, maybe on the own of the court or on the request, which would be oral or written, to be present along with the child who is testifying in the judicial proceedings. But there are some do's and don'ts for the support person. That support person may accompany a child to the witness stand, may be allowed to hold the hand of vulnerable person, may be allowed to take other appropriate steps to provide emotional support to the vulnerable witness, but he shall not firstly obstruct the view of the child to the opposite party or to the judge. He cannot prompt or influence the witness during testimony. He cannot discuss the evidence to be given by the witness. So these are the do's and don'ts for the support person. Now the third term comes the facilitator. So as the term itself reflects, the person who facilitates the communication of the vulnerable witness with other stakeholders. And other stakeholders are like police, medical officer, prosecutor, psychologist, defense counsel. And if any difficulty is being found in the communication of the vulnerable witness with such persons, then facilitator can be appointed, who could be interpreter, translator, or child psychologist, psychiatrist, social worker, teacher, parent, or relative, according to the need of the witness. However, when such witness is appointed, he shall be administered oath. What kind of oath? That he will pose questions according to meaning intended by the counsel. And whenever the facilitator is appointed, the questions will be posed to the facilitator, who will further ask those questions to the vulnerable witness, but with the intention which is there, which has been intended by the counsel. So this is the condition under which the facilitator can be appointed and how he has to work. Now there are some rights of the vulnerable witness prescribed. Those rights are that the prompt information to be given to the witness, his or her parents or guardian or support person, about the stage of the process with regard to the procedure of criminal justice, role of vulnerable witness, the importance, timing, and manner of his testimony, and even the ways in which the proceedings will be conducted. These guidelines have been framed by keeping in view the fact that the witness who is coming in the court in such a situation is not in the knowledge of the proceedings of the court. So we have to act accordingly. Even such witness has to be informed about the existing support mechanisms, because these are provided in the guidelines, but they are not known to them. So it is the duty to inform them that what mechanisms are available for the support of such vulnerable witnesses. Even the specific time and places of hearings and other relevant events have to be informed. Availability of the protective measures have to be informed to the witness. relevant rights of the child victims, including the conventions and what rights they have declared, and the progress and disposition of that case. The progress includes that what is the status of the accused, whether he has been granted bail or he is in custody, and what evidence is going on, and what decision has been there, and what is the outcome of the case, and what are the post-trial developments. So these are all rights of the vulnerable witness to be disclosed to him. Now next comes the pre-trial visit. As I have discussed in the definitions about the pre-trial visit, what is the purpose of it, but what has to be shown and what has to be discussed. It is the location of the accused in the dock, court officials, what are their roles, where they are sitting, who else can be there in the courtroom or in the gallery, location of the witness box, what is the basic procedure, its runway, run through also, the facilities which are available in the court, discussion of any particular fear which could be the vulnerable witness have with regard to the prosecutors and intermediaries. So the officers have to dispel that fear, trauma and anxiety. Then demonstration of any special measures. If the evidence is being recorded through live link, then the demonstration of that live link to explain how the deposition of the witness would be recorded. Now, the term comfortable environment has been used again and again in the POCSO Act, in the JJ Act, and now under these guidelines. Apart from the pre-trial tour, what type of environment should be granted to the vulnerable witness? It is the separate furnished waiting areas. As stated, that waiting areas shall consist of the toys and other articles for the children. Child may be allowed to testify from a place other than the witness chair, but having the frontal or profile view by video link during testimony of the child. That frontal or profile view should be to the opposite party. The witness chair can be rearranged to allow the child to see the opposing party only if he chooses to look at them. And even the judge has been dispensed with from wearing the judicial robe during such testimony. The other things are the testimony of the vulnerable witness should be recorded when he is well rested. He feels comfortable. Reasonable periods of break should be there during the deposition, and above all, testimony should be conducted in camera. Now, as the pre-trial tour has been there, so the evidence of the vulnerable witness has to be recorded, but before recording the evidence, the officer, the judge suo motu, meet a vulnerable witness, or it can be on the application. That too can be in the presence of both the counsels or in their absence. And it is only for the purpose of explaining the court process to the witness and nothing else. Then, for recording the evidence, first the satisfaction has to be there with regard to the competency of vulnerable witness. That is, if it is a child or of the person of any other disability, then the voir dire with regard to the competency of that witness. And thereafter, it has been prescribed that who are allowed to be present at the time of competence assessment. It is only the judge and the such personals of the court officials which which have been specified by that officer, the counsel for the parties, guardian ad litem, one or more support persons, the accused. But there is rider that if the court determines that competency does not require the presence of accused, he cannot be allowed to be present there. Next is the any other person who, in the opinion of the court, can assist in the competence assessment. Only these persons are allowed to be present in the courtroom at the time of recording the competency of the witness. Then this assessment has to be conducted only by the officer himself, and that too by asking questions which are appropriate to the age and development level of the child, but they should not be relating to the issues at trial. And they should only focus upon that what is the ability of the child to remember, communicate, distinguish between truth and falsehood, and appreciate the duty to testify truthfully. And this duty is continued throughout the deposition. Now comes the rules of deposition and mode of questioning. The court shall explain to such witness to listen carefully to the questions and not to reply by nodding or shaking head by speaking clearly and loudly. It should also be explained that to state specifically where that witness does not remember something, or to clearly ask to repeat the question if it is not understood. Now here again the duties have been assigned to the courts, what the court shall allow and what the court shall not allow to ascertain the truth. First is the court shall allow the questions to be put in simple language without slang or proverbs. Ensure that questions are stated in a form appropriate to the developmental level of the vulnerable witness. If it is a child, what is the age of the child? According to that, the questions have been framed. Protect vulnerable witness from harassment or undue embarrassment. Then the court shall avoid waste of time by declining questions which the court considers unacceptable, being improper, unfair, misleading, needless, repetitive, or expressed in language that is too complicated for the witness to understand. Further, the court may allow the child witness to testify in a narrative form. Put questions to the witness only by itself. The court shall put questions only by itself to the vulnerable witness. Then, if the witness seems confused even after repetition of the question, the court shall ask the counsel to rephrase the question. And what the court shall not allow, these are the questions which are carrying words having 2 or 3 meanings. Questions having use of past and present in one sentence. Question having multiple questions, which is likely to confuse the vulnerable witness. So this was with regard to the deposition. Now, if the deposition of vulnerable witness is not direct, then what are the measures which are to be taken? It could be by way of live link or using of screens or one-way mirrors and other devices. So this can be done by court on its own or on the application, which could be moved either by prosecutor or counsel or guardian ad litem. And testimony of the child may be recorded in a room outside the court through live link. However, if the court does not suo motu states about the recording of the deposition of the witness by live link, then the application has been moved. Then the judge may question the child in chamber or in some comfortable place other than courtroom in the presence of support person, guardian ad litem, prosecutor, and counsel for the parties regarding the feelings of the child about testifying in the court. And again, the chair of the witness or screen or other device be placed in such a manner that child cannot see the accused while testifying. And there are some factors, there are 12 factors which are to be considered by the court while deciding the application we have discussed here, which includes the age and level of development, physical and mental health, physical, emotional or psychological harm due to the trauma experienced by child, nature of the offense, circumstances of commission, any threat against the vulnerable witness, relationship with the accused, reaction to any prior encounters with the accused, which could be outside the courtroom or elsewhere or in the court. Reaction prior to trial when the topic of testifying was discussed by the parents or professionals with the witness, specific symptoms of stress, testimony of expert or lay witnesses, custodial situation of the child and attitude of the family, and other relevant factors. So these are the factors which are to be taken care at the time of deciding the application. So any record regarding a vulnerable witness has to be kept confidential to maintain the privacy of that witness, and it has to be kept under seal. It can be provided only on order, written order, that too on written request, and only to these 5 persons. Number 1, members of the court staff for administrative use, public prosecutor for inspection, defense counsel for inspection, guardian ad litem for inspection, or any other person which is determined by the court. Then comes the protective order. It has been prescribed under the guidelines that where the witness and where it is video or audio recorded, a transcript of that testimony shall be ordered to be prepared and maintained on record, and copies of such transcript shall be furnished to the parties of the case. Then tapes could be viewed only by parties, their counsel, their expert witness and guardian ad litem, and nobody else. No person shall be granted access to the tape or any part thereof unless he signs a written affirmation that he has received and read the copy of the protective order, and thereafter he states that he submits the jurisdiction of the court with respect to protective order, and if there is any violation, he will be subject to the contempt power of the court. So this is type of undertaking to be given by that person. And each of the tapes, if made available to the parties, shall bear the cautionary notice. This is the cautionary notice that the object and the contents thereof are subject to protective order issued by court in such and such case with such and such number. They shall not be examined, inspected, read, viewed, or copied by any person or disclosed to any person except as provided in the protective order. No additional copies of the tape or any of its portion shall be made, given, sold, or shown to any person without prior court order, and any person violating is subject to contempt power of the court and other penalties prescribed. So this cautionary notice must be there on the copies of the tapes, and no tape shall be given, loaned, sold, or shown to any person except the person who has been ordered by the court. And this protective order shall remain in force until further order of the court. But the videotape or the audio tape shall be destroyed as per the rules formed by the High Court. Now comes again the personal details whether to be disclosed. The guidelines provide that the vulnerable witness has a right at any court proceeding not to testify regarding personal identifying information, which includes all this. But if the court required to testify, then in the interest of justice, the witness has to state. Now again, there are some guidelines with regard to protection of privacy and well-being of child victims and witnesses. This is the expunging. What order can be there? Expunging the names, addresses, workplaces, professions, or any other information to identify the vulnerable witness from the public record. Refraining the defense lawyer and persons present in the courtroom from revealing any information tend to identify the child. Ordering non-disclosure of any records that identify the child till further orders. And assigning a pseudonym or a number to a child. And in such case, when pseudonym or number to a child has been assigned, the full name, date of birth shall be revealed to the opposite party, that is the defense counsel, within a reasonable time for preparation of defense. Now, continuing with these protection of privacy, to conceal description of the child witness, to examine behind screen using image or voice altering devices, through examination in another place transmitted simultaneously to the courtroom by means of video link, through a qualified and suitable intermediary. So these are the provisions provided how the testimony of the witness can be recorded. Further, it has been provided that trial should be held in closed sessions. And the accused should be removed from the courtroom and kept in adjacent room with a video link or one-way mirror visibility. But defense counsel will be allowed to be present in the courtroom. And any other measure with which the court feels necessary can be taken. And any information revealed by the child victim enabling the identification of the child shall be kept in sealed cover. And its inspection or certified copies are not to be allowed or made available. This is very important part. And there are some directions for judges holding criminal court. This is the high priority be given to vulnerable witnesses. They shall be handled as expeditiously as possible to avoid unnecessary delays and continuances. To recognize the developmental and physical needs of the vulnerable witnesses and accommodate them in the arrangement of the courtroom and throughout the court process, which could be by use of testimonial aids, interpreters, translators when necessary. Separate and safe waiting areas and passage should be provided. And the court should be flexible in allowing the support person present with vulnerable witness while testifying and guarding against unnecessary inclusion of support person. So balance has to be created here by the court. And next, to schedule the date as per convenience of the vulnerable witness. Some protective measures have also been defined. Suppose if during the proceedings, the safety of the child is at risk. So the court shall arrange to have protective measures, which could include the direct or indirect contact between a child victim or a witness and the accused. Any passing of any restraint order. Pre-trial detention order for the accused, or with restraint or no contact bail conditions. So in the bail, the condition can be impose that there shall not be any contact, or the accused shall not try to contact the witness or the victim. And protection for a child victim or witness by the police or other relevant agencies, and safeguarding the whereabouts of the child from disclosure. And last is the any other protective measures that may be deemed appropriate. So it covers the every kind of measure the court feels necessary to adopt at the relevant stage in the relevant proceedings. So this was all about the guidelines for recording of the deposition of the vulnerable witnesses in criminal matters. And now here I would like to play a video. This video pertains to VWDC Center in the Chandigarh District Courts, and it will give you a clear view that how the deposition of the vulnerable witness is recorded, where that witness is placed, where the accused is placed, and how the proceedings go on. Aman, will you please play the video?
We now proceed on to the room which is made for the witness. This room has a screen which is connected through video conferencing. The witness can see the proceedings which are going on in the court. There are toys in the room for the comfort if there is a child witness.
Don't worry about the voice. At some place there is no voice, but it will regain.
This is the room that is the reception area. The witness along with his relatives or friends, if any, would be seated. Now we proceed towards the courtroom. As we can see that the courtroom is fully equipped with a screen connected with the video conferencing. There is a room next to the courtroom where the accused would be seated. As we can see, there is a glass through which the accused can see the proceedings which are going on inside the court.
State prosecution.
और मुझे पहला विटनेस करवाने की परमिशन चाहिए। आपका नाम क्या है?
नाम रजिंदर सिंह है।
आप क्या काम करते हैं?
मैं प्राइवेट जॉब करता हूँ।
राजेंद्र जी, आप जो भी कहेंगे धर्म से सच कहेंगे।
मैं शपथ लेता हूँ, मैं जो कहूँगा धर्म को जानकर सच कहूँगा।
और इस केस के बारे में क्या मामला है?
तारीख 1 जनवरी 2018 को मैं सेक्टर 20 अपने घर से सेक्टर 7 की तरफ जा रहा था। रास्ते में 19 सेक्टर की मार्केट में एक शख्स एक बहुत बुजुर्ग आदमी को बेदर्दी से मार रहा था।
From my house in sector 20 towards sector 7,
उसको पहचानते हैं? क्या वो आज कोर्ट में आया हुआ है?
जी हाँ, उसको पहचानता हूँ और ये मुझे सामने लगी स्क्रीन पर नजर आ रहा है, राइट इन द कॉर्नर बिलो।
Second on the screen, attacking the senior citizen.
ऐसे मैं आपको और कुछ उनसे पूछना नहीं है।
Madam Hassan, I may kindly grant you permission to cross the Mahinder witness. Rajinder ji, Rajinder ji, ਤੁਸੀਂ ਪੰਜਾਬੀ ਸਮਝ ਲੈਂਦੇ ਹੋ? ਅੱਛਾ ਇਹ ਗੱਲ ਦੱਸੋ, ਘਟਨਾ ਵਾਲੀ ਦਿਨ ਤੁਸੀਂ ਕਿੱਥੇ ਸੀ?
ਆਪਣੇ ਘਰ ਸੈਕਟਰ 20 ਤੋਂ ਸੈਕਟਰ 7 ਵੱਲ ਜਾ ਰਿਹਾ ਸੀ, ਰਾਸਤੇ ਵਿੱਚ 19 ਸੈਕਟਰ 'ਚ ਇਹ ਵਾਕਿਆ ਹੋਇਆ।
I'm very person with Punjabi language. On the day of occurrence, I was going from my house in sector 20.
ਅੱਛਾ ਇਹ ਗੱਲ ਦੱਸੋ, ਉਸ ਦਿਨ ਤੁਹਾਡੇ ਨਾਲ ਕੌਣ ਸੀ?
ਮੈਂ ਅਕੇਲਾ ਹੀ ਜਾ ਰਿਹਾ ਸੀ।
ਅੱਛਾ ਤੁਸੀਂ ਮੁਲਜ਼ਮ ਨੂੰ ਡਿਜ਼ੀਜ਼ ਨਾਲ ਮਾਰ ਕੁਟਾਈ ਕਰਦੇ ਦੇਖਿਆ?
ਹਾਂਜੀ, ਮੈਂ ਦੇਖਿਆ।
Second on the screen, attacking the senior citizen.
Ask some query from my client.
Permission granted.
Question? Wait, please.
हेलो, हाँ जी सर। सर 3 जनवरी 2018। ठीक है सर।
PW1 Mahinder is examined. Now the case is adjourned to 15th January for further evidence on behalf of prosecution. The vulnerable witness present today in the court is safely taken out of the court separately, and the accused is sent to judicial custody and be produced in the database.
Yes.
So this is about the Vulnerable Witness Center in the District Court, Chandigarh. And it has been seen that how both the witness and accused, they don't come across each other. And if any question has to be asked by the defense counsel, he has to take permission from the court and then ask in privacy through the telephone link. And even the court has mentioned in the order that what kind of mode has been adopted to record the evidence. So this was all about these guidelines and the live video. And now comes the witness protection scheme. This is the witness protection scheme of the year 2018, which has been adopted in its entirety in the case of Mahinder Chawla by the Apex Court. The definitions have been defined in paragraph number 2 of the scheme, but I will take only the important definitions. That is the most important one is the competent authority to whom the application has to be moved. The competent authority is the standing committee in each district, which is chaired by a district and sessions judge. And head of the police in the district is a member. And head of the prosecution in the district is the member secretary. Then comes the live link, which is the same as we have done in the guidelines. And what are the offenses in which the witness protection can be sought? These are the offenses which are punishable with death or life imprisonment or an imprisonment up to 7 years and above, and also include the offenses under sections 354, 354A, B, C, D, and 509. Then comes the most important part, threat analysis report. This is a detailed report which has to be sought by the committee after receipt of the application, and it is to be submitted by the head of the police in the district where the investigation is going on, and the report has to be with regard to the seriousness, credibility of threat perception to the witness or his family members. So the report must mention about the credibility also and the seriousness also. And it shall contain other details, that is the nature of threat, whether it is to the witness, to his family member, and whether it is to the life or reputation or property, and even the extent, to which extent the threat is there, and the person or persons making the threat, whether they have the intent, motive, and resources to implement the threats. So this report TAR has to be in such a detail, mentioning each and every detail of the threat, its seriousness, its credibility, nature, and even about the person who is threatening. This is the flow chart, that the application before competent authority has to be moved through member secretary, that is the head of the prosecution in the district. Then TAR has to be obtained and submitted by ACP or DSP within 5 working days of the receipt of the order. Whenever it is ordered to be filing of the TAR, it has to be there within 5 working days of that order. Then competent authority on receipt of the application should interact with the concerned witness, which could be in person or through electronic means. And again, the application has to be disposed of within 5 working days of the receipt of TAR. So looking into the gravity, looking into the fact that what threat has to be there, and this is the urgent matter to be dealt, the disposal of the application, the filing of the report has been time framed. Now, when the protection order is passed, the protection order to be implemented by the witness protection cell or the trial court, as the case may be. But the overall responsibility will be of the head of the police in the state or the UT. And here I must disclose that this scheme provides 3 kinds of protection. That is the identity protection, then the change of identity, and third one is the relocation of witness. So when the change of identity or relocation of witness is there, that protection order has to be implemented by the Department of Home of the state or UT. And after monthly follow-up report has to be filed by the witness protection cell. On the basis of this monthly follow-up report, order has to be reviewed quarterly by competent authority. And in case there is need of revision of the order, then the fresh threat analysis report has to be called from the ACP or DSP. So this is the flow chart. This is how the procedure has to be followed. Now coming to the types of protection measures. The protection measure can include ensuring that witness does not come face to face with the accused, either during investigation or trial. Even monitoring of mail and telephone calls. Arrangement with the telephone company to change the telephone number of the witness or assign him or her an unlisted telephone number. Installation of security devices, which could be CCTV, cameras, alarms, fencing, or security doors. Concealment of identity of witness by referring to him with changed name. Emergency contact person for the witness. Close protection, regular patrolling around the witness house. Temporary change of residence to a relative house or a nearby town, escort to and from the court, and provision of government vehicle or a state-funded conveyance for the date of hearing. Holding of in-camera trials. Here I must tell you that in Delhi courts, there is a provision of the car which takes and drops the such witnesses, and they don't have to come on their own vehicles. Then the protective order can include the allowing of a support person, usage of specially designed vulnerable witness courtrooms, as we have seen, ensuring expeditious recording of deposition, awarding time-to-time periodical financial aids, and that too from the Witness Protection Fund, and again any other form of protection which is considered necessary. Now comes if the application is for identity protection or the change of identity and relocation. Again, it will be through member secretary, TAR has to be called upon. Then competent authority will follow the same procedure. But here on passing of the order, Witness Protection Cell is under the responsibility to protect the identity, which include name, parentage, occupation, address, digital footprints. And during sustenance of such an order, Witness Protection Cell shall provide detail of such person who can be contacted in case of emergency to call the witness. Even new identity to the witness can be allotted, but providing of new identity and the supporting documents is not that the rights, educational, property and professional rights of such witness are affected. But that identity will not deprive the witness from such rights, and those supporting documents will be acceptable by the government agencies. And whatever the expenses are incurred on the relocation of the witness, that will be borne by the authority from the Witness Protection Fund. Again here, as the object is to protect the identity of the witness, so confidentiality has to be maintained and record has to be preserved till pendency of trial or appeal. And the hard copy of the records can be weeded out only after 1 year of the disposal of large court proceedings, and that too after preserving the scanned soft copies of the same. What if the complaint has been found to be false? In such case, the Home Department of the concerned government can initiate the proceedings for recovery of the expenditure from the Witness Protection Fund. And if any review has to be filed by any of the aggrieved party, which could be witness or police authority, that has to be filed within a period of 30 days of passing of the order. So this was all about the Witness Protection Scheme. And this is the performa, this is the form which has to be filled if the witness protection has to be sought under the said scheme. So these are the details which are to be mentioned, and this is the undertaking about by the witness who is seeking such protection. So this is all about today's webinar, and we would like to invite your questions on the feedback form. And thank you so much. Over to Harshali ma'am.
Thank you very much, ma'am, for enlightening us on the various provisions of recording of evidence of vulnerable witnesses and protection of witnesses in criminal matters. You have also, ma'am, elaborately covered the Witness Protection Scheme 2018. I hope this webinar will help us all in dealing with the matters concerning vulnerable witnesses. As ma'am has also said that we have already sent the feedback forms to you through SMS, And we are looking forward to the questions that are there pertaining to the webinar. This video would also be available on our YouTube channel, and you can view this video for further viewership as and when required. So till the time we meet again with another webinar, Namaskar.
Namaskar.